During Migraine Awareness Month, there's been a lot of discussion about migraine as a disability. And as requested by you, we decided to get some more information. Here to help us talk about the legal side of whether migraine is a disability is Laura Cottam, a solicitor at the Australian Centre for Disability Law. Thanks for joining us.
Thanks for having me.
All right, let's start with, what is the Australian Centre for Disability Law? What do you guys do?
So we're a community legal centre based in New South Wales. Unfortunately, as our name suggests, we don't actually cover the entire of Australia. We cover New South Wales. So we support people with disability in New South Wales and their legal issues. The majority of what we do is disability discrimination law. So we provide advice and representation to people who are making complaints to either Anti-Discrimination New South Wales or the Australian Human Rights Commission, also the Fair Work Commission and New South Wales Civil and Administrative Tribunal. We do some court work. It's limited. We're quite small. We're part of a network of community legal centres around the country. So we work with other centres as well. We provide education, sort of community legal education such as this, on various legal topics. We also do policy submissions and sort of just do a variety of different things. So if you have a legal problem, you're in New South Wales and you have a disability, we'd love to hear from you.
Thank you so much. All right, let's start with the basics. Is migraine legally considered a disability?
The answer is yes, very clearly, I would say. So the best thing to do is, if you're not sure if your disability is covered, have a look at the acts and the definitions. So I appreciate that Migraine Australia is a Australia-wide service. So I thought looking at the Disability Discrimination Act, which is the Commonwealth law, that's the best place to start. You look at Section 4 interpretation and it goes through all the different things of what constitutes a disability. I won't bore you with all of them, but I'll read you a couple which I think migraine would definitely fit into. Total or partial loss of the person's bodily or mental functions, total or partial loss of a part of the body, the presence in the body of organisms causing disease or illness, or the malfunction, malformation or disfigurement of a part of a person's body. Obviously not all of these will apply at all times, but appreciate that migraine is something that comes and goes and is different for different people. But I would say you would definitely be able to fit what happens to you when you have a migraine into one of those definitions. So definitely it is considered a disability. Similar definitions exist in all of the state-based discrimination acts as well. So in New South Wales, it's called the Anti-Discrimination Act, New South Wales. And also in the Fair Work Act, which is the Commonwealth Employment Law Act. So definitely it is something, the disease itself and the manifestations of the disease. Interestingly as well, it's worth noting that there includes a disability that presently exists, previously existed, no longer exists, or may exist in the future. So you can be covered if someone thinks that, you know, you had a migraine before, you may have one in the future, discriminating against you on that basis. Those kinds of things also come.
Well, we can't change our genes. We have migraine all the time. It's the attacks that come and go. So it doesn't matter even if you're well now, if somebody knows that you perhaps have a history of migraine, they still can't discriminate against you for any reason related to your migraine. Well, for any reason, hopefully.
Well, look, the only caveat I would say, in an area of public life, if we're talking about discrimination law, so it's not personal dispute, someone calling you names, being mean to you, it's got to be protected. So you've got to have a relevant disability and you've got to be a protected area of public life. So things like employment, education, goods and services, all that kind of stuff, definitely you should not be discriminated against because you migraine in all of those things.
All right. So one of the stories that we hear far too often is that people are getting managed out from their workplace, right? So it's not blatant. It's not, you keep taking too much time off for your migraine, so we're firing you. It's they make it really difficult. Now, is that legal?
Look, that's a
difficult,
hard question.
Okay, let's start at the top. Can you be fired because of migraine? Full stop.
Not full stop, but it's never full stop. Like if someone says to you, I'm firing you because you have migraine, of course not. That is disability discrimination, very clearly direct disability discrimination. But as you say, it's more insidious than that. It's usually a process of managing out, oh, you can't quite do this, you can't quite do that, not getting those things done. Key thing I'd say to people is you don't have to disclose your disability, but if you don't, it's really hard to get the help you need and say that people aren't treating you fairly because of it. So the more upfront you can be and the more requests for adjustments you can make, the better protection you're giving yourself. It is a hard one because obviously at some point, if your requests are becoming to the point where you can't do your job any further, it can, you know, the employer might be justified in saying, well, look, this can't continue, but they've really got to be clear about the justifications, and it can't, often employers just put you in the too hard basket or say, you know, we can't make those adjustments. We've never done it before. We don't want to do that. And that's not appropriate. And that can constitute discrimination. So if you're asking for adjustments and you know that you can do your job if you just had sort of flexibility, or if you just had a change of workstation, or if you just had, you know, ability to take different days off, come in late, whatever you require, and you know you could still do the job just slightly differently, and the employer doesn't want to do that, then that could constitute discrimination. So it's unfortunately it's not cut and dried of Unfortunately, every factual situation obviously will be different. I mean, there's two defenses to for an employer if they're trying to remove you because of your disability. One is that you've requested adjustments and they can't make them because it would cause them unjustifiable hardship. That's sort of proving they've got to show it's going to cost them too much money, it's going to cause too much problems for everyone else, it's not going to cause enough benefit to you. They've got to prove that. If you were to take legal action, they've got to prove that's the case. The other defense is if you really can't meet the inherent requirements of the position, even with the adjustments. And again, we see a lot of employers who say, oh, well, here are all these inherent requirements. And actually the reality is very few jobs have an inherent requirement of being at your desk at 9 a.m. every morning or doing a particular thing in a particular way. It's just that employers get into the habit of having people who can just do that. We've always done it like that, and they get scared of something new. And that can often be what happens. And that's, as you talk about, that kind of process of managing people out is often just because of preconceived notions of we've always done it like this, we've got to keep doing it like that.
Yeah.
It doesn't mean it's right and doesn't mean it shouldn't be challenged.
All right. So you mentioned adjustments. What are reasonable adjustments? What's that term mean?
It just really means, what do you need to be able to do your job or do, access services or access education or accommodation on the same basis as someone without a disability? Mm-hmm. So what do you need to have changed so that you can actually function in the same way as other people? And that's different for every person. So it's got to be reasonable. And so reasonableness is often it's a fun legal term that's hard to define and will depend on every circumstance. So what's reasonable for a really big employer to do for you may not be reasonable for a small business to do for you. And that can be hard. But you've got to work out, I suppose, in situations like migraine, what are the triggers? What are the problems that you have? What do you need changed? And it's good to have a wish list to a point in terms of everything you need changed. And is there some sort of compromise? Can you work with some of those things? What I always say is have things in writing, talk to your doctor, talk to your employer, have a sense of here's what I need, here's how I think, and that's why I think the list you've got in Migraine Australia already about, there's resources section about the kind of things, the flexibility you need and how talk about how you could work with your workplace, look at their policies, know the flexibility, know the kind of leave policies. That's really good. That's a really good starting place for a discussion when you think about, okay, what do I need? But also what is the employer going to need? How can we work together to make sure it's working for everybody? Yeah,
so it's about good communication and working with your employer. Yeah. All right, for those who can't work anymore, are they able to access things like DSP and NDIS?
Now, unfortunately, that's beyond the scope of what we do because it's quite specialised and I'd hate to give people the wrong advice. So I'd suggest talk to Centrelink, everyone's favourite thing to do. There's also a welfare rights centre in every state. They're a community legal centre that provides advice on Centrelink issues like the DSP, so they should be able to talk to people through what you need. And the NDIS as well. Again, I know it's always fun to talk to the NDIS, but in terms of eligibility and things like that, they're the best people to answer those kind of questions.
Because we talk a lot about workplace rights and we talk disability discrimination. Are there other situations and scenarios where your rights are protected? So like say, for example, in school, if you've got a kid with migraine, maybe they're in high school, are their rights for an altered learning experience, if you will, protected?
Yep, look, exactly. So there's actually a long list. Let me point you to our lovely Using Disability Discrimination Law in New South Wales brochure on our website. But there's a long list of the areas of, I just find it easy to have a look at the actual. There's a long list of areas of public life in which you are protected from discrimination. Okay. And they include things like employment and work, education. So that includes schools, it includes TAFEs and universities. So again, you've got the right to request reasonable adjustments and not be treated differently because of your disability. Good services and facilities, that includes a wide range of things. If you can fit it onto the definition of a service or a facility or a good, then you're going pretty well. It's not just shops, it's all sorts of service providers. Access to public places, again, so premises and things like that. Accommodation, so that's including renting. Land, clubs and associations, sport, and various Commonwealth and local government laws and programs, but they're obviously quite specific, so you have to have a look at those. But there's vast areas of public life in which you should not be discriminated against because of your disability. And so if you feel that you are, then you can take action against.
So if you do feel like you've been discriminated against for whatever reason, perhaps you've been denied something, perhaps you've been kicked out of something that you enjoy, what's the next thing that you do? How do you take action or how do you get more info?
So I always say the first option is try and complain to the actual service provider or whoever's caused the problem themselves directly. See if you can resolve it in that way. Work out what you want, make the complaint, go through their process and see how you go. If that's not going to work, or if there's already been issues and that's not going to happen, you can make a disability discrimination complaint. So there's a federal option available to everyone around the country. That's the Australian Human Rights Commission. You've got to do that within 6 months of the discrimination occurring. So it's worth being aware. You've got to kind of move quickly. In New South Wales as well, we have the Anti-Discrimination New South Wales. You can do that within 12 months. There's an equivalent body of state body in every state as well. So have a look at your local complaints bodies. It's free to put a complaint in. You just put it in writing, explain what happened and what you want. Then usually the process is they accept it for investigation, send it to the other side, say, what's your view on it? They give a written response usually, and then they try to get the parties together for a conciliation. In these interesting COVID times, they are still doing remote conciliations via telephone, not necessarily via Zoom. And the goal is to say, give you a chance to explain what happened, how you felt about it, so the other person actually understands, and to try and get some sort of resolution. Okay, how can we move forward from this? And you can be quite creative. You could want something like an apology. You could want them to change their training, change their policies and procedures, do some, more disability awareness training. You could require them to pay you some compensation, pay someone else, change something else, whatever you can think of, and whatever someone else is willing to agree with you in a negotiation can occur. If you're not happy, if it doesn't get resolved at that point, you've got then further court and tribunal options, and they depend on which sort of complaint body you're in. And also the option is as well, if you're in employment, if you have been dismissed because of your disability, you've obviously got the option of complaining to the Fair Work Commission. Again, short time frames, you've got to do that within 21 days of being dismissed. But if you are in the workplace and you haven't been dismissed, but you feel that you are being discriminated against, you've got the option of making a complaint of general protections within 6 years. Right. So you can actually do it while you're still at the workplace, and that can help you kind of come to a sort of a conciliation negotiation and try and get it resolved. So it's just worth being aware of those sort of options as well.
And because there will be lots and lots of comments on the video, if I don't say it, you can also talk to your union if you have a union.
Yes. And look, and I can't say that enough to people actually as well. The amount of people who call us for advice and, I've got my union, but I haven't spoken to them. Speak to your union. You're paying your fees. If your delegate's not helping you, call the head office and ask to speak to their lawyer, because every union has one. I used to be one, so I can tell you, but it amazes me how many people do not access that. You're paying your fees. Call them. Keep calling until someone provides you with advice.
And it's okay to join a union kind of, because you need them now. If you haven't been a member before, they don't care. They'll still help you.
Exactly.
That's what they're there for, and they're great. But thank you so much for all of that information. I think it will inform a lot of people, because there are some ongoing discussions in our group about our rights and all of that. And we're really happy for all the work that you do at the Australian Centre of Disability Law.
Oh, thank you. Look, and people are always welcome to contact us as well. We've got a website, we've got an email address, so people can call us. So if people need further advice or assistance, please give us a call.
Thank you.
Great. Thanks. Okay.